All right, it's 1:07. We'll go ahead and call the meeting to order. Begin with our roll call of members.
Constable Sean Kennington,
Here.
Chief Mike Harmon,
Here.
Judge Stephen Abels, Chief Robert Crawford, Curtis Howard,
Present by video.
Kevin Lawrence,
Here.
Bob Leonard,
Here.
Lieutenant Lizette Rivera,
Present by video.
Dr. Jonathan Scheinberg, Dr. Stephen Tate,
Here.
Clay Taylor, Sheriff John Wayne Warren Valdez.
Here.
Thank you, we have a quorum.
All right, this afternoon, I'd like to welcome everyone and thank TCO for all their work they put in. Definitely want to thank Chief Harmon. The last two meetings I haven't been able to be here. To take over and keep everything running. Welcome our visitor, I believe, Chief of Corsicana.
Corrigan, big city of
Corrigan.
Corrigan, Texas.
Corrigan.
First red light come out of Houston, that's Corrigan.
Glad you're here and are interested in what we're doing. First item, take care of approval of the minutes of December 5th, 2023 advisory committee meeting. Hopefully everybody's had a chance to read over those. Is there any additions or corrections that need to be made to those minutes? I'll entertain a motion to approve.
Make a motion.
We have a motion by Chief Harmon, second.
I'll second.
Second by Dr. Tate. Any further discussion on the minutes? If not, all in favor of approving, say aye.
Aye.
All opposed? All right, motion carries. Under item 3, receive and discuss subcommittee recommendations for minimum standards. Do we have any recommendations from the physical fit for duty subcommittee? What about the psychologically fit for duty subcommittee? Do we have anything to add?
We
Go ahead.
sent out a fourth draft, fitness for duty, that was based on some of the recommendations from the last meeting, including cleaning up some of the language. And then in addition to that, Dr. Tate has included in their definition fitness for duty, evaluations, and minimum standards. So it's kind of an overview of what we have provided the rest of the committee.
And I believe the third draft was emailed and the fourth draft, everybody should receive that. We got here today, is that?
Very little difference between the two. There was just kind of a hanging sentence that I couldn't remember what it didn't make sense, so I just removed it. So if it comes back to somebody remembers what it was, we will certainly reinsert it if need be.
And that was under 100.11, is that correct?
Let's see. What I believe so, yes, sir.
Under 4, discuss and take action on matters related to developing a model policy prescribing standards and procedures for the medical and psychological examination of new licensees, existing licensees, for those who employ an agency has reason to believe a new examination is necessary as established under Texas Occupation Code 1701.16067. Hopefully everybody's taken a chance to look over the, like I said, the third draft and the fourth draft only has that one minor change on, I believe it's between, at the end of page 4, beginning on page 5, where that was removed. Do y'all wanna go down, through this by each piece of this, or do you wanna just open it up. Colin, do you have a preference on that, or what would be best?
Constable, we can do either. We can go, paragraph per paragraph and, if everybody's had, you know, if they believe we've arrived at the state based on all y'all's good work, we're amenable to either. So whatever the committee's preference is.
As far as the content that's in this model draft, the model policy, is there anything anyone on the committee sees that needs to be looked at, changed, or added?
I had one question regarding defining something in 100.7 fitness for duty evaluations, and it's gonna be in I guess subsection 1, threshold considerations for a FFDE subsection 1. There's a couple of things in here that talks about derives from direct observation, credible third-party report, and other reliable evidence. On the issue of credible third-party report, absent the obvious, such as a spouse or somebody of that nature, which I still think, you know, there can be questions about it. Are we defining what credible third party is? Is this an anonymous phone call to the chief of police? I have concerns about that being so broad that it just kind of opens the door for a lot of subjective definitions of what credible third party is.
I'm guessing being as I do not see a definition for what credible third party is, then we have not set forth exactly parameters, what that means.
And I didn't know, maybe Dr. Tate has some experience or examples that may give us some guidance.
You know, this was taken from the 2018 guidelines for fitness for duty with IACP, so I don't know who drafted that piece of it and what they meant by it. So I can't intelligently respond to that. I can see why you might be concerned about it. So we might need to decide if we want to keep that in there or not keep that in there, or say something that's more germane to what you're concerned about.
If we had derives from direct observation or other reliable evidence, would credible third party, did it not fall under the other reliable evidence? Is it?
I think it could.
Is it being redundant to have both, or I mean, can we?
Yeah, is it just that if we strike that credible third party report phrase, does that get us further down the road?
I think it does. I think it just kind of, you know, direct observation, of course, I would think that we're talking about department supervisors, department heads, things of that nature. But other reliable evidence, I think would include other officers or family members or somebody coming forward and making their concerns known.
Does anybody have any heartburn with striking credible third-party report?
I don't.
Can I make a suggestion or, so we have instances where we'll have third-party complaints, and that's written up and sent up to the chief level officer who then makes the determination. So can we on 100.2 policy, can we say something like, when deemed necessary by a chief level officer of the department, who ultimately makes a determination whether the test is conducted or not?
Where were you looking at?
So on 100.2,
First page.
we just, on the very first page. So can we add language there where we say, instead of under limited circumstances, it's when deemed necessary by a chief level officer of the department. And they take into consideration any witness statements, observations, things like that.
So I'm trying to understand, have we switched from the discussion on 100.11 and going to 100.2, or are we merging that discussion together?
Can we,
Which horses?
Because we were just talking about the discussion of the credible third-party report. And then we switched to
in 100.7.
Yeah,
We're in 100.7.
100.7.
Sub one.
Everybody agrees we are striking credible third-party report out of that, correct?
Correct.
Okay, so that's stricken from the draft. Now that we have that closed, we're now gonna be talking about your 100.2.
Well, her 100.
Yeah, sorry, I was looking at you, but I'm,
okay,
all right, so.
Well, I mean, and I think the fact that it's a chief law enforcement officer is actually spelled out in 100.9. That's who's actually requesting it, so I'm not sure.
Yeah, I think her concern is dealt with, when it talks about, the process for non-sworn or process for sworn, process for peace officers.
And I don't know, I'd wanna take out the under limited circumstances. I thought that was part of her recommendation.
But I think 100.2, I don't know that it necessarily needs change since it does, in my opinion, since it does address who is going to be questioned in the.
Yeah, I think it, 100.9 or 8 and 9 invest in the chief law enforcement officer, the authority to actually make the request. So I think in total,
Okay.
It's spoken to it.
Do you agree that
Okay.
that 100.8, 100.9 would address who will be requesting that? Okay. All right. So 100.2, we're okay with at this point, as written? Everybody?
Yes.
Okay.
Okay.
Any other things that we need to look at, address, or change on the law policy?
can we take a look at the 100.8,
Okay,
the process for non-sworn?
all right, go ahead.
It states that if it's deemed necessary for them to take a test, that they will use their physician. Can we change it to, we have the department provide that examination, and if the person doesn't agree with it, that they can bring in their own physician?
I believe the last meeting we discussed that in detail, which physician would be used first.
Yeah, I think the
Kind of mirroring the
personal
civil
position
service, yeah.
first comes from 143
Right.
civil service. Is you get to go to your doctor first for the
Correct.
determination. And so that's why, that's how we arrived at that, at least by my recollection.
Right,
The department
so that we don't
doctor comes on
supersede state law.
if you don't agree with the
Yes,
first report.
and then both parties can go to the panel of three
Right.
if either doesn't agree with the other's findings, yeah.
Whatever, yeah.
Okay,
And I think that was to conform to 143, because if we did it the opposite way, then we'd have 143 cities who would have a different process than everybody else. So could cause some
Okay.
confusion.
okay. Just reviewing this with some of our staff, there was just some concerns that a personal physician would be um, maybe would be biased. So in order to just not, just to take that away, the department would be the one providing one that is, has the best interest of the city.
Well, and I think that was one, like I said, mirroring 143, also the concern could go the other way as far as if the department is the one paying for it, or the city or the county, is there gonna be a bias there? So
Bias against the licensee.
against the officer or the licensee, so I think that's
Is it set to where you go to the first one up is the
personal.
personal?
And then second,
Isn't 143, the first one up is the city or the counties?
No.
Is the first one?
First
First
one.
one.
Oh, and then you go, yeah. And if the governmental entity disagrees with it, they can send them to the one, and if those two disagree, then it goes to a panel.
so I think, I mean.
Yeah.
To keep it to conform with 143, if we left it this way and it still allows
Yeah,
the
that's right.
government entity to have the protection of having theirs look at it if they disagree with it, I think was the thought process last meeting.
Okay.
Any other concerns or questions? Sheriff?
Well, and I've touched on this a couple of times. It ends up, for lack of better terms, dying on the floor. We have bullet points to decide whether or not someone needs to be looked at by a psychiatrist. The abrupt change of behavior, the alcohol abuse, other factors. We still have not addressed the physical. We talked about it some, and I believe you brought up a great point. If we start doing yearly evaluations, the first one, we may lose a 10 or 15-year veteran. And I get that. All I'm asking is there any way, every agency needs to have their own test. I'm not saying T-Code needs to develop a test. What I'm saying is, if I have a guy tomorrow, when I get back to work, that I think needs to have a physical evaluation, is he gonna flunk it? Shake your head, yes, probably 85% of the time. Because there's a reason why he was in the shape he was in to begin with. So in my opinion, we're setting him up for failure, and that is not what I want to do. A lot of agencies have gone to fitness programs and wellness programs. What I'm asking is there any thought process to saying, as part of this, by year 2026, I'll just throw that year out there, every agency needs to have a physical fitness test annually.
I would be opposed to that.
Wow, we do weapons.
I understand that, but weapons are completely different. As you pointed out, you got a 22-year veteran who's now put on 30 pounds, and there's no way that he can do the same physical agility as a 22-year-old.
That's not what I'm saying. There's Cooper standards. There's all kinds of standards that are based on your age that you can factor into this test. It's not a cookie cutter where me being 59 years old and the 25-year-old I just hired has to have the same exact standards.
It's the same process we used in the military. I mean,
Correct.
So, but the fitness for duty was never designed to implement a Cooper-style test or a fitness for duty test. It was basically if the officer broke their ankle, they go back to the doctor and the doctor evaluates their ankle to make sure that they can perform the fitness, the duties related to their job description. And if the ankle is good to go, the officer gets cleared fit for duty. If the department wants to, on its own, issue a hiring standard and implement some sort of fitness test as a condition of or some sort of requirement of employment that says, hey, every year you're gonna do a fitness for duty, and I think you do that in your city, chief. That's up to the individual agencies. I don't think the state should be regulating every single agency across the state. Some of these states, some of these small cities and counties struggle mightily just to hire officers because the pay is relatively low. You have a lot of officers who retire from big cities who end up in small rural towns and counties as a second career. Their experience is invaluable. I mean, it took them 30 years to get there. But are they gonna be able to do a 2-mile run? Should they be excluded from being police officers? We have probably a large portion, or I won't say large, I'll say a number of officers across the state that would be out of work if there was some sort of fitness for duty implemented on them. But at the same time, they're outstanding officers. Some of them are the best officers in their departments or in their commands. I don't think that that's what we're here for. We're not here to put a statewide physical fitness level on every individual officer. We're here to make sure that if they get hurt before they can be returned to duty, that the doctor performs the functionality of that injury. That injury passes knee, shoulder, elbow, whatever it is. If an individual agency decides that they want to implement a fitness for duty, kind of a carrot and stick type of thing, hey, if you can pass the fitness for duty exam, you get a day off or you get a bonus. That should be left to the individual agencies and departments.
So I agree with that. I think the state can come up with a model policy as far as what we're doing right here. But individual agencies should also build on this and enhance to their particular agency. I mean, like we did in Cedar Park and surrounding agencies around us, Georgetown, Round Rock and stuff like that.
Well, and I think that's where 100.3, member responsibilities, it is responsibility of each member of this department to maintain physical stamina and psychological stability. I think that's where your local is gonna then springboard or should off of that to do what they feel is best for their community and their agency.
It's my understanding.
Does the city have insurance for your officers?
Health insurance?
Health insurance or workers' comp? What's the workers' comp based on? Are you at high risk? Are you at medium risk? That's how they make that determination. How many OJIs have we had?
Yeah.
If you have a direct correlation between an OJI that's physical, blows out an ankle, hurts your shoulder arresting somebody or fighting somebody, do we not do that 100 times more than using our firearm? I would say it's even more than that.
It's my understanding that the scope of this was for medical fitness for duty, which is separate from physical fitness, physical agility. And I think those are two separate things. And I get what you're saying, and hold on a second, and I appreciate that. It's my opinion that agencies should have physical fitness standards throughout an officer's career that recognize their age, their things like that. But I don't know that as far as this goes, I think the scope here is more akin to is whenever you apply for an academy and you apply at an agency, there is the physical agility test, which is jumping over a couple things, running around a track, dragging a dummy. And then there's the medical evaluation that you go to a doctor for. And those are separate in and of themselves. They're discrete between themselves. This is more dealing with that medical assessment, not the physical agility assessment. And so I think that here we're looking at more of the officer that got injured and they were snow skiing and got injured, or they got injured in the line of duty, whatever it is, and now they're ready to come back to work and their doctor has said they're ready and good to go, but the chief or the sheriff or the constable says they're still limping. I don't know that they can do this. And whether they're in good physical shape or they're in poor physical shape, regardless, and now says, I want you to go and be reevaluated, they have to go and be reevaluated for that medical condition to make sure that they can do what's in the job description that HR has created for a peace officer for the city of XYZ. But again, I think that cities and counties, I encourage them to have physical fitness standards throughout their career. Now, but that's individual, and what we were talking about here, those have to be particular to that job. And you can't, when you do a job validation study for a Texarkana Police Department, that can't translate to a Beaumont police officer or a sheriff's, an Ector County Sheriff's deputy. Ector County has to do their own job analysis and assessment. And so I don't know that we could do that in this realm here for a statewide thing. So it would be my recommendation to this, that you stick purely to a medical assessment. You got psychological assessment, you got medical assessment, and to me, reading all of this, as I've done for a while as I came into this, I believe the legislature's intent was those things separate from the physical agility side of that. And maybe at some point the legislature looks at that and says we need to have that, but that's a separate issue from these. And the easiest way to look at that is you go to most police departments, most sheriff's departments, when an officer or when an applicant applies, they have a written exam, they have an oral interview board, there's the background, there's the physical agility test, there is the polygraph, then there's the medical, there's the psychological. They're all in and of themselves, separate. That's my take on it, for what that's worth.
All I'm saying is that there's a lot of devotion to the psychological part of this. I get it, rightly so. I've been doing this a little while. But we're really not addressing any of the physical aspects of this, other than the doctor says you're good to go unless you got a limp. Or you can't pick your arm up.
What do you mean by addressing the physical? Maybe I'm not following you.
We have rules in place here in these policies and how the administrators can go about notifying TCOLE if they pass or if they don't. But we're not addressing what we have: alcohol and drug abuse. We have personal expressions of disability. We have an abrupt and negative change in a member's normal behavior. There's nothing in those bullet points that address any physicalities that are observed by their first line supervisor or their administrator.
So perhaps it's not a terrible idea to have some examples
Yeah.
that would say, and quite honestly, to your point, that would make sure that chief administrators, sheriffs, police chiefs and whatnot understand that this is different than a person who's out of shape, who can't run very far or anything. That's not what we're talking about. We're talking about an injury. We're talking about something, and that would, so that no one does confuse it down the road. So I don't know that that's what you're necessarily wanting out of it, but nonetheless, I think some examples could help that and say, hey, don't get caught up in this just because you've got an officer that you think needs to go exercise or eat better. This isn't what this is about, unless you feel like that they medically are unfit to
So
perform.
I have a couple of suggestions that might address this issue, which you've just touched on. I would just direct attention to what's stated above, A through F. Such indications may include, but aren't limited to, the following. You could, and I would suggest the committee that's dealing with the medical side of this, add 4 to 6 examples, and you could put a little title up there that says, here are some examples of psychological features, here are some examples of medical features, but you might want to put in a caveat or a disclaimer that would fit what you're talking about. And maybe you could collaborate with the the medical team, the medical subcommittee, to think about what that disclaimer would include. And then the medical subcommittee could come up with some appropriate examples that would fit into this rubric that we're trying to look at. Because I thought about that too, that we have examples, but in my mind, I know that it's not all inclusive. It's,
No.
these are just examples. So, but you know, human beings that we are, we might say, well, we're gonna stick to these 6. But if you have examples of both sides evenly, it's gonna help intellectually address that and be more thorough.
I'm just,
Wouldn't that be covered under 100.9? Fitness for duty examination, whenever a question arises as to whether the officer is physically complete fit to continue.
what's the first, so what would be, I guess that's where we would put,
Well, you can't define everything, I mean, you can give some
No.
examples.
And I think,
But I think you can, I mean, common sense and good judgment would tell you that that guy right there can't even get up. If you're at the range and you're having to kneel down to shoot, and Officer X can't even get up off the ground without assistance or not at all, common sense would tell you they may need to be sent to a fit for duty exam.
And if I could offer this, Sheriff, I don't disagree with you that every agency has a right to expect their officers to be physically able to perform the duties. But the duties differ from the type to agencies around the state. If you work for the lottery police, not meaning to offend anybody, but you might have one entirely different, distinct set of standards there than what you would have at Cedar Park PD. And we've already got a standard in statute with regard to psychological. Everybody has to go through a psychological. Sometimes we have to go back through psychological. So there's already a bar that has been set there. The physical stuff, I agree with Chief Stevens. That's agency by agency. Yes, it needs to be in your job descriptions. And when you send somebody to a doctor, they need to have the job description right there so they can say, okay, is this person physically fit? Chief, you weren't here for one of the meetings. I mentioned an officer that fell down on the scene one day. And he was so damn big, it took 4 other officers to pick him up. In my opinion, that's a fitness for duty issue.
Right.
You know, if your gun belt is taller than my wife, we got a problem.
met her, she's not
the
that
whole
old.
reason I keep going back to this is 2 reasons. One, I want to protect my guys. I would rather them not be a police officer than have to bury him. Does that make sense?
Well, that's an
It
internal
does.
issue.
No, I understand that,
I
but
don't know if the
when
state.
I'm thinking about this, I'm thinking about the people that work for me and the people I've worked with.
And you're
I'm trying to
right.
help.
But remember, this is a model policy that is sort of the minimum standard.
Correct.
There's nothing that precludes an agency from expanding it to bring about
I
physical
agree.
fitness requirements. And
Right.
it's,
Now, maybe 20,
But for the
2
ones that
years,
won't.
4 years, the legislative body will say, hey, we wanna.
Well, and as hard as they press on law enforcement from time to time in the legislature, we all will know, not this past legislative session, but the one before,
This may be just the beginning,
it may be
It
just.
may
the-
be.
you know?
but again, this is what the agency must do. Now, that the agency can, if they want to take this and springboard into, I think what Colin was saying, if they wanna then take this and say, okay, well, we're gonna start implementing physical fitness standards to go beyond mere medical minimums, they certainly can. They just have to have the minimum, and this is a model to get them there.
Should,
And so,
just for the sake of discussion, should our model policy say that the agency should include whatever their standards are in the job descriptions that are going to be provided to the medical or psychological professionals that are going to be?
I don't know, it would have to be in this policy. I mean, that's, in my opinion. I mean, I think we can add to and get in the weeds so much that, I mean, I think our duty was, like I said, it's about medical clearance, not physical fitness clearance, which I agree with Sheriff Valdez. Everybody should be physically fit if they're gonna be on the streets in law enforcement.
But again, medical clearance for one department might be
Right.
different than it is for
Exactly.
another department. So the departments need to notify these professionals what the bar is, I think, so.
Well, I think, you know, just like your psychological, if you send them, they need a job description, what their duties are, and can they,
And I think that language is actually in the policy
Right,
when
it
you get
is.
to that section.
Okay, all right.
and I don't know that if we had 4 or 5 examples,
Yeah.
that's gonna clear up the other 30 that we don't have.
Well, and in previous
limited to, though.
discussions,
Right, but
in previous discussions, when we talked about the medical, we saw those as being wrapped up in A and F as either it's a change in performance, you know, if you look at A, abrupt and negative change in members' usual or normal behavior, we kind of default to some psychological, but if dragging your leg behind you is a physical behavior,
You saw me walking.
Go up wearing a neck brace.
you know, these are meant as example triggers for a supervisor to say, raise their hand, say, hey, there's something wrong with Cullen. You know, and so this is just what starts, you know, a process that ultimately, Jeanette said earlier, ends at the chief level as to whether or not this fitness for duty, which this is a job event. If I'm unfit, I'm no longer employable in many cases. Or I'm off on some kind of leave until fitness is arrived at. So in previous discussions with the committee, we saw even the physical in these 6 examples.
what if A, where it says an abrupt and negative change in the member's usual normal behavior, we just follow that up with and/or performance, just to spell it out where it's,
Now, performance, you're still not.
if you can't draw a gun, you can't handcuff, I mean, all those performances aren't there if you can't perform because of an injury. Like I said, not,
Well, and F talks about suffering from an impairment or condition requiring some intervention, because this is a type of
right,
job-related intervention.
F definitely would go into it.
So I'm just gonna say this, I appreciate the sensitivity that you have with this. For my purposes here, with what we're discussing, as it stands right now, I think it covers everything we need to cover. If we get into the weeds and be specific with it, I think that would help with that, which goes back to my earlier suggestion. But I don't know that we're gonna get any more mileage by discussing it any further. I think it's time to move on. And I'm not trying to be disrespectful, it's just that I don't know that we're gonna squeeze this any further. It states what it states, and it's, you know, we're looking at minimal standards. If we add the caveats that I mentioned earlier, which would touch on what you're talking about, that would be sufficient as well, and go in more detail. But I think the way it stands right now, it addresses that if you look into it specifically.
I also would like to point out that we do have at least another month or at least one more meeting before we have to, at the end of February, have this done and wrapped up. So I mean, if somebody feels that they have some kind of language or they find something that they think may be appropriate, they can still submit it to the respective subcommittee or even this body as a whole and make the recommendation that it be included in the policy if we're all in agreement. But I do agree, Doctor, I don't think we're gonna get anything resolved other than what we've talked about already. And I understand, to the sheriff's point, you don't wanna get saddled with an employee who is not only a danger to themselves, but also the people they're working with. But at the same time, I think we can go too far afield where we start making more and more people ineligible to be in law enforcement. I think that should be left up to the individual agencies, that the chief, sheriffs and constables have a right to set a level of, or standard of fitness as, not only as a condition of employment. Before you decide to take this job, know that we do a physical fitness test every year. And in order to maintain your good standing with our agency, you must be able to pass it. But I don't think to now tell, 80,000 plus law enforcement officers that going forward, they're gonna be held to this standard and we're gonna lose a good significant number when we can't even hire and fill the positions we already have. I don't think that's what this committee was set out to do. I think we were set out to do the medical side of fitness for duty, psychologically and physically, but the medical side of it.
I'll say this, if I may, and at the core of it, you're all right. We do need to take a look at what the medical ability of officers is, the physical fitness ability of officers is. And there is a job task analysis that's been done many, many years ago that really does need to be revamped, and we've been looking at how we can best accomplish that. That would kind of get to the, okay, what does this officer need to physically be able to do in order to properly do this job? But at the same time, I think, Robert, you're probably right that this is expected to be, and this is the balance that TCOL constantly finds ourselves in when we get legislative directives is how do we broadly apply this to all law enforcement agencies without getting so prescriptive that it's infeasible for one versus another. So I think you've probably reached a good balance on that with the model policy that you've come up with, knowing that each individual agency can take that and be much more prescriptive within that agency for it.
And I think Sheriff Valdez brought up, the being injury, the insurance and all of that, and being on the budget side for 13 years as mayor. There's no doubt when we saw an increase in insurance, something that we would look at what that was, and we'd go to the chief or we'd go to whatever department head and see what are we doing wrong or what can we correct. So I think that would be the driving force but it was local control that, we got to say, we're gonna put these standards in because we need to reduce our liability. And I think, and I'm all about local control as much as possible. Nothing against TCO, but
As in mine, just sometimes we all need a little push.
but I agree a whole lot with
I see it coming
Sheriff
down the road
Valdez.
though.
Sir?
I see it coming down the road though.
But I also agree with Dr. Tate. I think we are at a good point. We've discussed, I think we've met most, if not all, the objectives of what we were put here to do.
Would it help in listening to the discussion, I agree with what everybody said, and certainly I think everybody's agreeing in separate ways here. At least consider maybe a format change to your purpose and scope or policy paragraphs by inserting medical and psychological fitness for duty. Maybe that drives home the point that you're talking about. So it is a reminder, it is both, but that also accommodates local control standards there. But just to let everybody know that this procedure we're talking about applies to both. What those standards are still obviously left to whatever the local standards are.
Correct.
So a suggestion.
I don't have any objection to that if you want to distinguish that it's both medical and psychological.
Let me make sure I understand the language. So we would, 100.1 would start monitoring a member's medical and psychological fitness for duty is essential.
Well, the partner remains fit for duty and able to perform their essential job functions both medically and psychologically.
Or just monitoring a member's fitness for duty, both medically and psychologically, is essential for the.
That's it.
That's it right there.
That's it.
Perfect.
And you put that in right after members, psychological.
Members fitness.
All of you got there? So we got that change, 100.1.
Just for thoroughness, could you repeat what we were thinking about changing it to?
On 100.1, you wrote it.
So the way I have it is monitoring a member's medical and psychological fitness for duty is essential.
Well, the way I had
Safety
said it
involved.
was monitoring a member's fitness for duty, both medically and psychologically,
Okay.
is essential for safety and welfare.
Yeah, and that's, I like that.
Yeah.
And
Before we move on, let's make sure that it's in the right order.
okay.
Do we wanna have a motion for that?
I think when we get done going through everything, if everybody, we'll go over with the changes, and if everybody's okay with the few changes that we made, then we'll wrap it up in one motion, if that's okay with you. Alright. Colin, you wanna read that back, make sure we've got it?
Okay, what I have is monitoring a member's fitness for duty, both medically and psychologically, is essential for the safety and welfare of the members of the department and the community. And the only other substantive change I have so far is the removal of the phrase creditable third party under 100.7.
That's correct, that's the only two, as far as content changes that we've made.
One of the things that we discussed, last time, I know, Dr. Tate provided some, detailed information on what a fit for duty is and the minimum standards. Is everybody okay with that language in here? So it'd be number 100.7 and 100.11.
I saw no problem with that language.
Yeah,
Anybody else have any issues with that added language?
Sorry, just repeat the language.
On the
100.7 and 100.11.
Right, and what was the language again specifically?
just the definition of the FFD, fit for duty, and then the threshold consideration.
Okay, yeah, no, I don't have any.
And the IACP references.
So I think we, last meeting, all agreed
2018.
on that's inappropriate. Having issues. Anything else?
I didn't know if there were, that was the one thing I wanted to ask. I noticed that we had 113 put resources, both of those resources are specific to the psychological fitness for duty. I didn't know if anybody on the medical subcommittee had any references that they wanted, know that there's books that doctors utilize to do these evaluations.
I don't know of anything that would.
I don't know as much work has been done, or as much work has been done in that region. Again, separating medical and fitness, there's a
Yeah.
lot of fitness standards, but base medical standards.
Fitness standards. Some of them, I don't even understand why they do it, but what's a 16.5 inch stretch from a table? Just reach over, I'm not making it up, I think it was Montana. You just reach over and you have to be 16.5 inches. Gives you flexibility, I guess, in your lower back. I don't, Travis County used to. I don't see that. I don't see the need to change that or add unless somebody,
Unless there's a good one out there.
I don't know of anything we would benefit from.
UPS is still tweaking theirs.
I'm sure.
Yeah.
We did get something from the good doctor last time. We talked a little bit about it. Certainly, I think it's something, the reference he was using is ACOEM guidance for medical evaluation of law enforcement officers. And that's the American College of Occupational Examiner.
Did we all get that? I don't remember.
These were the forms that were left on the table for us.
Oh, I wasn't here on that.
American College of Occupational and Environmental Medicine.
Yes,
That's it.
occupational
Bingo.
environmental medicine. So I think, I don't know that it changes any of the policy content, but I think the doctor provided it as a potential reference, so we could certainly reference them as we do,
I think so.
Just add that as a 3. as a
yeah, so
resource.
we would add the third reference to,
Sheriff, you can keep that set. I have an extra set here, so.
Thank you.
just for something to put out there since we're on this aspect, the American College of Occupational and Environmental Medicine, is that what we mentioned?
Yeah.
Okay, cause they have specifically a section for fitness for duty.
But this is just a reference guide, it's not.
Yeah, it's just a reference
Yeah,
guide.
we're not
No.
actually, you know,
Getting it.
setting
No.
standards, we're just
It's a
saying that
reference
this
But as
way.
a resource.
As a
Yeah.
resource, yeah.
Right.
That's what we were doing, just trying to add a resource to the 113.
Yeah, and so we can get that,
Add that.
I've got the stuff on that.
What else? On this model, this draft, this model policy. So we have,
Yeah, no, I don't think, not in this state.
so the only content changes we have to the draft, the fourth draft of this model policy is 100.1. That addition, 100.7, striking out. And then 100.13, adding that resource for medical.
That's what I have.
Any other questions, concerns over this fourth draft besides those three changes?
Got a minor edit here on top of page 2, the first paragraph. I think between unable and effectively, there should be a 2.
Okay.
That work?
Work.
All right, and then I
That didn't
didn't,
change the content.
no, it didn't.
Added, as far as formatting and punctuation, if you see something, then I think we'll definitely be okay with making sure it looks professional.
Yeah, in terms of formatting, we'll reconcile this committee's output with the other model policies without changing the content that's.
So the numbering may end up being a little different or whatever the case is, so they're all consistent. Thank you for bringing that up, Colin.
I did have a question also on 100.11. We kind of discussed this earlier about the job descriptions. The third paragraph says, finally, when conducting the FFDE, it may be necessary for the examiner to receive background and collateral information, and then it lists what that could be. Should that be changed to it is necessary?
No, I would leave, my suggestion is to leave it as may.
Yeah.
I don't like is because that mandates and then I think that the doctor should be left to make that determination on what they need, because that's a pretty big laundry list. I even had some concerns about
Well,
internal affairs investigations, formal citizen public complaints, use of force incidences, because as you know, on our side of things, if those things are unfounded or
Yeah.
unsubstantiated, they end up in a G file in 143 cities, but they, 143.089B prohibits their release.
Mhm.
I understand medically, they may be required to release some type of information necessary for the evaluation, and that's why we have it in here, that it remains a part of their confidential medical file, so that prevents it from getting backdoored, to the public.
Mhm.
But I would request that it be left as may.
Well,
Same.
I guess my concern is that the information below is an inclusive list. It could be some of this, but doesn't have to be all of it. However, if it left as may, then the examiner doesn't have to get any information regarding their past and recent performance when conducting the examination.
But I think the supervisor,
Do that.
supervisor at their discretion would give that information. I mean,
Right.
Well, and I think that goes back to, Dr. Tate's made the argument about professional practice. Professional standards are gonna require a practitioner to request those things he or she needs to do the.
And my argument would be we leave it to the professionals to tell the department, this is what I need, rather than the department just sending everything over lump sum to start off.
Yeah,
It's that
no,
shotgun blasting.
I'm not saying that they should do that. It's just how it's currently written. It's how it's currently written, it seems like the examiner doesn't have to get anything.
And in reality, there may be those situations where the examiner wouldn't need anything. issue is so significant that regardless of what the background is, it's not gonna happen. Kind of the way that I see that working.
Okay, that works.
Leaving it as is. Anything else? Alright, so we have this draft with these three changes. And if we don't see anything else we need changed, do you want to make a motion to approve and submit this with these corrections to TCO at this point? As our model policy?
I'm not opposed to that. I mean, like I said, we're not knocking up on the door yet. I didn't know if anybody felt strongly enough to wanna.
Yeah, we do have, and I can share a timeline with you, we are starting to knock on the door. We need to get these submitted, committee submissions by February 8th, so we can get them into the commissioners' notebooks for the pending commission meeting, so that window is closing.
Right.
Well,
And that's based on how far everybody's come too.
and I have no problem meeting again, but if there's not a reason to meet, because we have vetted it as much as we're gonna vet it, other than just running down rabbit trails every now and then because something else pops up. I said, if we know that this is just a basic model policy that the local department can expound on, then I'd entertain a motion that we approve this to be submitted to TCO with the three changes that were discussed.
Well, I don't know if you all heard this or not, but what I understand is that if any of the committees completed this process by January 20th of 2024, each of the members would be given a 7-day pass to go on Royal Caribbean cruise.
We were hoping to keep that safe right now.
That's your motion?
I don't know that it was Royal Caribbean. I'm not sure, you think, it wasn't Royal Caribbean, it's a
I think it was
cruise.
Lower Colorado River Authority cruise or something.
DPS.
DPS, exactly.
We know a guy.
It says highway patrol on it.
It's in the water. So
So is that a yes?
so
I'm not sure.
in a form, Dr. Tate has made a motion. This model policy with the corrections listed. Do we have a second?
Without having to pay for it.
Without. All right, Chief Harmon seconds. Is there any other discussion over this model policy before we take a vote? Not being any, all in favor, say aye.
Aye.
Aye. All opposed? All right, motion carries. Item 5, discuss and take action on future advisory committee meeting dates and location, including video conferencing.
Before we get into that, did we wanna discuss the rules?
Sure.
A little bit? So it should have been one of the, no, I don't even have it.
It's 217.9, you should have a paper that looks
And Aaron, let me lead in, I'll turn it
Go for it.
over to you.
Yeah.
Committee members, there was discussion from the first meeting, there were some obvious concerns in maintaining the confidentiality of any type of proceedings for a refusal for fitness for duty review under the model policy you just approved. We had discussed, as the statute says, a proceeding before the commission, and after a great deal of discussion, we as staff took the question to the State Office of Administrative Hearings. We had a discussion with their general counsel and the chief administrative law judge, and we've talked about this to some extent in previous meetings. But what you have before you is a procedural rule. Instead of before the commission having the proceedings at the State Office of Administrative Hearings, they would be confidential proceedings. The information related to them would be confidential. The proceeding itself would be confidential. And what would occur is there would be a proposal for decision issued at the SOA level. That would come back to the commission. And obviously, a lot of the evidentiary questions and proceedings that would be at SOA, would necessarily, it would be a very narrow question before the commission whether or not to approve the proposal for decision or not. In keeping with the spirit of confidentiality. As a result, the commission would approve or not approve an order that was, or excuse me, a proposal for decision issued by the SOA judge, and the order issued by the commission would be subject to judicial review. This is for, this was made in conjunction with the State Office of Administrative Hearings. We're certainly open to any thoughts or questions you may have.
So you're asking if we are okay with the language that's given here? My only thought would be, it says the 30th day. I was just wondering if we have an issue with any timeline. It looks fine to me, but sometimes circumstances don't allow, for the limitation of time for that individual. I don't see any reason for this to be changed, but
And that's a great question, Dr. Tate. The 30 days come from the statute, it comes from the statute. And we're having ongoing discussions with the State Office of Administrative Hearings and how to best facilitate that 30-day deadline, whether that's having one docket day a month, or however we can do it procedurally. But that's still in the works, how they're going to accommodate that 30-day deadline.
My only question is in the heading, shouldn't it say medical or psychological?
And can I ask one question for consistency's sake? Can we make an agreement on whether it's examination or evaluation?
Statute.
It says examination in statute.
I think it does.
That's
Different places.
All over the place.
1701's examination
It
of
does say
license.
examination, so with your permission, there are several references to evaluation. Can we amend those to say examination?
Speaking of, in the model policy, it says evaluation.
There are places where it does.
And for consistency, in the model policy, change evaluations to examination.
That's the question.
Those start with E. Anybody have a problem with that?
Doctors call it anyway.
If that's what the statute already calls it.
Yeah.
Yeah.
Stick with that.
Thank you.
I think everybody agrees.
Appreciate it.
Any other on this?
Here to help.
7.9,
Golf clap.
you get to go on the cruise with us.
Margarita's on me.
All right. All right, number 5, discuss and take action on future advisory committee meeting dates and location, including video conference. I am guessing we have just approved this. We're not looking at setting another date to see each other, or do we need to?
Well, I don't think the committee in total needs to meet, but I believe that we'll be working probably mid-February for presiding officers and assistant officers of all 3 committees to come together to talk about presentation and reporting to the commission. So, and there are some outputs from the committees that may overlap a little. Misconduct personnel files, this committee. So John, anything else you need to speak to? So we'll be working with the 2 of you to set up that with the other committee chairs.
And I'm guessing once you get the formatting done, you will send this model out to everybody, so.
We will.
And plenty of time to where anybody saw a drastic change or something that we needed to look at, we could schedule a meeting to that point if we had to. Okay. So we can set one now for the committee. Okay. Does everybody agree with that? Since we're not setting a meeting, do we need to take a motion on that we're not setting a meeting?
Motion, your motion. Motion.
All right, receive public comment on any topic without action. Any comments? All you.
I'm for anything making things better.
All right.
That's a public comment.
There's not any other comments.
Was that the comment?
I want to thank you for the committee's work, the diligent effort put in between meetings for subcommittee and research, and I want to tell you that we appreciate your participation, both, this is a volunteer gig, and we understand what it takes to do this. So we appreciate everybody coming and helping us with the burden of meeting our sunset bill. So really appreciate your time. We're always here, you know, pick up the phone and call us when you need us. We will need your help, I'm sure, in the future as we implement this. This is gonna be statewide implementation. So again, thank you on behalf of the commission and the commissioner certainly for putting yourselves out this way and hopefully helping us make the state a better place, policed by better people.
When you said our help, did you mean someone to blame? As we implement this, is that?
Well, we know who gets the blame.
Someone to point fingers at?
Yeah, I think we should go on record as saying that we were floundering and stuck on High Center until Chief Stevens got here and got us.
I'm looking forward to the blowback from all three of them.
Like how you used the word
Deal.
floundering, you're so used to fishing.
Nice, that was well
Always
played.
maintain plausible deniability. There we go.
So I had one procedural question just for confidentiality's sake. I know at the beginning of our committee meeting, and I don't know what the language was, but basically we were to keep what is said in here, what we say in here, it needs to stay in here. At what point are we able to disclose the findings of our draft to our own agency, or is that something that's gonna come forth?
I'll speak to that, Dr. Tate, and I don't necessarily, I don't, certainly from staff side, we've never advocated any confidentiality on these. In fact, it's just the opposite. I mean, everything, it's wide open, you know, it's obviously.
Oh, good, because I've been going back to
I would say
social.
it's an open meeting, we had been executive session.
Yeah,
Let's open
we've
it up.
recorded everything. It's wide open.
We forgot to ask you not to be here.
You know, certainly if you share anything with your organization, let them know that you keep in mind, as we discussed, that it is still, it's a work in progress, it's finalized by the committee, but obviously the commissioners, they're the ones who adopt it or not adopt it, or adopt the changes or whatever the case is. Just keep that in mind.
And these documents will be published in the Texas Register for public comment for anybody and everybody who would like to see them.
That's right. And just to give and Cullen spoke to this earlier, the general timeline is early February, about the second week of February, these materials will go to the commissioners. The commissioners will look at them. The meeting is, the workshop and meetings are February 28th and 29th.
26th and 27th.
26th and 27th. And you were somewhere in there, you guys were listening.
Close.
Is the presiding officers or assistant presiding officers, or whatever combination, will present at either the workshop or meeting or both, depending on how that gets worked out. Then, as was mentioned, assuming all the model policies get adopted, they'll go to the Texas Register, receive public comment, and the model policies and or rules will come back in April at the next commission meeting for hopefully final adoption based on whatever public comment, any changes that need to be made and necessary to that. After that, there's an education and outreach opportunity on the agency side, and then depending on what the discussions with the commissioners are, implementation at some point in the near future.
We can certainly use all of your help in distributing the word on that.
The last thing we have to discuss is the date of the cruise with Icon of the Seas
Yeah.
from
I'll tell you.
Florida.
So in order not to violate Open Meetings Act, and since we've discussed everything on the agenda, I'm gonna ask for a motion to adjourn, and then we're gonna set our date.
I'll make a motion, we adjourn the
We have a
meeting.
motion, have a motion and a second to adjourn. All in favor, say aye.
Aye.
Whatever date's good for you, I'm fine.